the role of intellectual property rights in the economic development, the Indian experience. So first of all, let me say that this topic of role of IPRs in economic development is a very old one. Nothing very perhaps it's been quite well examined by several scholars around the world. So there is a whole host of literature available on this. But I think even today, I think this is very important because many of us actually do not see how the India actually looked at it, in developing its own intellectual property rights regime, particularly its patent regime. I will be focusing more on the Indian patent regime in my talk in the next 15-20 minutes. So if you look at that way, this experience of a country's, trying to balance the intellectual property rights legislation, particularly patents, in order to acquire technology is very important. See, countries always, this is my area of my interest because countries always try to design or, they thought this is one of the way to get technology is to have a patent regime or a, IP regime, which could actually help investors or the inventors to come to India and actually, take advantage of that technology within India. So this is the one of the reasons why there is a long history relating to this development, particularly with regard to India. So now, if you go into the historical aspect, the India, the intellectual property rights regime, now as it is called, otherwise the patent and copyrights or industrial property as it was called much earlier, was introduced to India, the modern IP system, what we could call, was introduced way back in the 1850s. Essentially, this was a colonial sort of a legislation which was extended to India by the British. The whole lot of things were happening in the European continent at that point of time. I'm not going to get into that because that led to the adoption of Paris Convention for the Protection of Industrial Property in 1883, followed by another one on copyright or what is called as protection of literary and artistic works known as Berne Convention. These two are actually essentially in the European initiatives, and it happened in Europe, and essentially most of the countries introduced these legislations in the colonies in order to protect their own interests. That's number one. So a lot of things have been written on this. Now only the it took almost another 100 years, perhaps around. Patents and Designs Act of 1911 is the first act which was actually introduced as a separate act within the Indian context. The entire Indian subcontinent, in fact, which includes South Asia as well, where this was actually introduced. So the entire South Asia, even today, I think Bangladesh, Pakistan continue with the same Patents and Designs Act. But I think India took a different sort of a course in the post its independence. That's what I'm going to look at in the next few minutes. Now, India realized much earlier that it is important for it to have a very effective patent regime or a copyright regime. Now, what we term as intellectual property right regime to achieve certain kinds of economic growth. How do you link economic growth and technology transfer? All these are areas which have become very important in the post-Second World War, particularly within the United Nations. Now, you will see that in the early part of the United Nations, particularly in the UN General Assembly, a number of reports and studies have been made with regard to the linking the development and the intellectual property rights regime, particularly patents. There have been a number of studies by United Nations Conference on Trade and Development, as we know, UNCTAD, and several other institutions actually referred to it. See, for example, the earlier, we were speaking about permanent sovereignty over natural resources. The resolution passed by the UN General Assembly referred to it. And then later, Charter of Economic Rights and Duties, the declaration on the new international economic order in various ways actually referred to the importance of technology. And in order to get technology, how to develop patent regime or intellectual property rights regime was actually discussed at that point of time. So in the 50s and 60s and 70s, you will see that whole lot of developments happen in the context of within the context of the United Nations system. When I say which included a lot of other institutional frameworks within the United Nations system. But at the same time, there was also a constant struggle between countries to transfer technology, regulate technology, and most of these were actually held by the multinational companies, big companies, and big companies were actually reluctant to transfer technology unless and until their own terms were met. So this was one of the main issues, during this period. Now, in this context, you will see India, post-independent India in 1947, immediately after it became independent. In 1948, India took up this, idea of developing its own, for example, its own patent regime. So you have the first committee, which was constituted by the government at that point of time in 1948, what is called as Bakshi Tekchand Committee. He was a judge of the Punjab at that time, the High Court, and then he was asked to provide certain amendments, certain ideas towards how to actually have an effective patent regime. So to the existing Patents and Designs Act. In fact, that was one of the earliest attempts by India in the 1948 and 50s to look at how to, develop a regime. So, but interestingly, this did not stop. But I think because of the developments which were taking place globally, India decided to go for a patent, particularly patent, because copyright, trademark, and other related intellectual property rights, those, which are important for the countries, were India was quite compliance in terms of it. It was quite compliant with that. But regarding patents, India thought patents are crucial for economic growth and also crucial for the, which is of course been quite well, I said already, laid down. And then also what kind of a patent regime, for example, in case if you need to have a technology transfer to take place, should be developed. That was the idea which I think at that point of time the government went into. Now, in order to do that, the government actually established in 1956 or 57 the committee under the leadership of what you call one-man committee, you can say. It's called Justice Rajagopal Iyengar Committee, which was constituted in 1957. Rajagopal Iyengar was a judge of the then Madras High Court. Then he, in fact, this is a very interesting, he gave a very, very interesting report after a study of more than 2 to 3 years. He's the first person, actually, this needs to be actually examined, recorded. This report is available, and this report, I think, is one of the classic reports prepared by Judge Rajagopal Iyengar, Justice Rajagopal Iyengar. He, in fact, went around the country and looked at the invention patterns, and then also looked at the technological necessities of our country, Indian necessities, and then also he looked at the global technological landscape and also the kind of patent systems that existed. And he gave a report and also gave certain ideas as to how a particular IP, particularly the patent regime, should be developed. See, then he suggested the kind of ideas which should be put into a proposed patent act, actually. So the report was given by Justice Iyengar in 1959. This was a very elaborate report, and this report was placed before the Indian Parliament. And it went to a debate within a select committee for nearly 3 or 4 years. So you can see how Indian Parliament or Indian government at that point of time very keen to develop a patent regime which actually can take care of India's economic growth. So it took nearly more than 10 to 15 years. Finally, the Indian Patent Act, for example, which came in 1972, is based on all these efforts, particularly the recommendations provided by Justice Rajagopal Iyengar. Now, if you look at the Indian Patent Act, because I said I'm going to emphasize more on patent because patent has a direct relevance to technology, actually. Because it is the inventions which are, we invent, it protects invention. Of course, intellectual property rights protect different kinds of subject matter. Copyright is protected. Copyright protects different kinds of subject matter. Now we have plant varieties. Now we have, designs and all, geographical indications. I'm not going to get into those details, but here the patent is something which is extremely crucial. Now, all the IP, of course, are important for economic growth. But at that point of time, the Rajagopal Iyengar committee report actually looked at how patents could be helpful in actually getting transfer of technology and which could be very useful for economic growth within India. So now, of course, the whole debate I was mentioning earlier is happening within the United Nations systems as well, particularly for countries which actually became independent, developing countries, and many of the poor countries around the world actually wanted to design a kind of a regime, IP regime, which could help them get technology, which could help them actually imitate up to a point. See, these are very important. Now, you need to have a regime which India tried to balance in its act, that, this is again, IP, in IP, a lot of IP theoretical framework, that innovators or inventors do not want to actually get away with their inventions until and unless, of course, they have to be given a reward, they have to be provided with sufficient statutory backing to protect their inventions. All that is there. But at the same time, if you give them a monopoly, since it's a monopoly, IP is a monopoly granted to through a statutory backing for a definite period. So if you give it, you are creating a situation where the balance between public interest and the private rights have to be balanced. So the India tried to do that in its Patent Act by providing, for example, if you look at the Chapter 16 of the Indian Patent Act even today, because now it has been amended quite a bit, but Chapter 16 still provides in Article Section 84, 85, and 86, it provides the basis of the Indian patent law. So Indian patent law, particularly for a country like India, I think this is a model sort of a legislation at that point of time, because it says that the patents are not granted merely to create a monopoly. It says by giving out patents to inventions, it says patents have a public role, patents have to be given, and there are two important aspects which actually Chapter 16 of the Indian patent law actually refers to. That these two important aspects are the affordability, because patents particularly have impact on the pharmaceutical sector, medicine sector, and related, food processing and kinds of things. So there are two aspects I mentioned in Chapter 16 of the Indian Patent Act. It refers to is one is affordability, second to meet the reasonable requirements of the market. So these are the two basic things which Justice Iyengar actually mentioned, because he examines in his report not only the existing legal frameworks relating to IP, particularly patents around the world, and he points out that this is how you can actually balance. Majority of the countries actually did that by bringing out legislations, trying to balance local working. This is one of the most problematic areas from the time of Paris Convention in 1883. For nearly 100 years of sort of negotiations, 6 revisions actually have gone into it. How to actually, when you take a patent or in a particular country, whether it should be worked or not worked, or it should be kept idle for all the years if it's a very important technology. The local working is one of the most important ideas. Secondly, how far you actually develop your skilled workforce, or what state of the art, or a person who reasonably understand the technology, that is also very important. For that, you need to allow a bit of imitation, which is called reverse engineering. So reverse engineering up to what point you can do without violating the existing legal framework. So the Indian patent law, looking at all the existing legal regimes relating to IP at that point of time, framed a regime which tried to balance all these ideas. Unless you allow your population to understand, imitate, reverse engineering. See, this is a big debate actually between technology haves and technology have-nots, okay? technology hubs will not allow even today you to get the technology unless and until you actually for various reasons. Apart from monetary reasons, there are other reasons, and they want to keep it. Evergreening is one of the issues which we have already know about it. So obviously, this is the reason why the developing countries like India allowed this kind of a balance. So there should be an amount, to an extent, amount of reverse engineering. There must be allow imitation, local working, but without violating the basic rights of the inventor. So this is not new actually. If you look at historically in the 19th century, this happened in Europe. In Europe also the same problem existed. Many countries in the 19th century, at that time industrial revolution, they actually they most of their patent laws they eliminated actually. Some of the countries which, in order to get the technology, in order to allow their inventors to or people to understand the technology, to get it the technology transferred and get it integrated into their population. So this is called as 19th century patent controversy within the European context. And at the same time, we have literature which is available, how actually this was used. IP was used as a tool to actually augment and increase the monopoly rights of certain kinds of inventions, and not allowing others to come and do research in that area. So that became an issue in the 70s and 80s. Essentially, most of the multinational companies used it as a tool to actually lock the markets, or to keep the markets for themselves. The idea of taking patent, this is one of the reasons which have been actually provided in various reports, is to IP as a strategy to capture markets. For example, that's what has been happening even today. It is happening in many ways, and countries actually try to design laws in order to balance this kind of right. So Indian Patent Act particularly tried to do this. And if you look at and this is of course and this was not taken lightly. And the one of the reasons why the entire negotiations relating to intellectual property rights, as we call it now, went into GATT, the Uruguay round of negotiations in 1986, and it was actually launched in there. One of the important negotiating items was intellectual property rights, and the developing countries resisted for nearly 2 to 3 years. Later, of course, as a quid pro quo to a textile agreement within the WTO context, they decided to agree to negotiate. India and other countries were in the forefront to oppose this actually. So historically, we should know these ideas. But TRIPS agreement is one agreement which actually came to prominence because they wanted to. The global South and global North actually had a real conflict on this issue, because this has a renaissance in the economic development issues. So and particularly technology trade related issues. And if you look at TRIPS agreement, I'll just mention about this and stop my talk. TRIPS agreement, all of us know, is a minimum standards agreement. For the first time, unlike other IP treaties, now here you have a TRIPS agreement which actually defines every part of the intellectual property right, particularly patents. And patents, it's actually equates local working with importation. It actually says in its preamble, it is not just it's a private right actually. Now, what is the public component now today with the pandemic? What India, South Africa, and others are requesting, particularly South Africa, in the 2001 Doha round with TRIPS and public health declaration coming to fore. If you look at that way, so if you look at TRIPS and public health declaration in 2001 and till now, if you look at the development, what I am trying to tell you will become very evident. So now, the TRIPS agreement itself is a testimony where, of course, countries have become parties, and you need to implement them. India implemented, took time. India couldn't implement them immediately. So America, one of the first earliest cases before the WTO dispute settlement mechanism was actually on the Indian implementation of the patent act relating to exclusive marketing rights. So because of various political reasons, it couldn't be done that point of time. So if you look at the Indian trajectory, later, of course, India amended its patent law 3 times, and then all the amendments were included from product and process to it became product patents in all the sectors, including pharmaceutical sectors. So today we have a patent law which actually tries to be comply with the existing TRIPS agreement. Now, TRIPS agreement, of course, Article 1 says clearly that you shall implement the agreement. So now we have a scenario at the global level which actually seeks to impose certain kinds of obligations on countries, including India, which we'll have to adhere to. Now, I just stop by saying last one word. Now, when we are talking about, there are new subject matters which have come up actually into the global arena. India has to take care of it. Biodiversity, genetic material, traditional cultural expressions, and then several areas which actually where developing countries have, particularly global south, has edge. And existing IP regimes do not actually allow them to be patented. So public domain issue is a very important issue. Now, once something is in public domain, you can't actually patent or take IP on this. So obviously, copyright works differently, trademark works differently, plant varieties work differently. But what India has done is now India has come out with legislations in all these areas. Registration is being done. We have a Biodiversity Act. I think there is a sort of clash going on between countries because about now actually it has gone beyond the existing legal frameworks, because now with the technology being like, for example, standard essential patents, and then one particular product will have 10, 15, 20 or 60 odd patents which are actually held by certain multinational companies. How to get it, how to actually open a manufacturing base or do innovation in a country like India, it is actually difficult. So you need to, there are FRAND regulations which have come up, which need to be negotiated privately between multinational companies. So we are into a very different area now. India is trying to do it. In 2016, it came out with a patent policy, but still America, actually USTR, United States State Representative, looks at India every year and then puts them in whatever least priority watching list, has to negotiate India's existing standards of protection of IP. So I think I conclude by saying that this is an extremely important area. Still, I think the idea of economic growth, and the economic growth, I take it in a very large sense, and just not that. Economic growth also could be investment. Now we are into FTAs, and then there are separate negotiations are going on. There are separate chapters on IP. So because they believe that TRIPS and data and related issues have become very important in recent times, particularly post-pandemic. I think these are the areas which need to be looked at, and India is trying to negotiate. Certain bills are still pending in Parliament. Data protection bill is pending in Parliament. There are a couple of other bills which relate to protection of some of the very important aspects of IP are still pending in the Parliament for various reasons. I think I stop at this because the Indian experience is quite exciting because of various reasons of its growth, of its business, trying to negotiate between the private and public sector innovations, particularly in relation to pharmaceutical sector, because we have a big pharmaceutical sector. I think by saying that, I'll just stop at this, because this is an area which needs to be looked at both historically and also look at the trajectory which we are going to have in the next few years, which will determine the Indian development model. And I have a lot of things to say, because you have climate change technology, there are other issues, all are coming into this idea of economic growth. So with this, I thank the CMR University, particularly the Honorable Dean, Professor Subramanya, and all the other colleagues for giving me an opportunity to share few of my reflections on this topic. Thank you very much.